Regulations Module 1. Module Objectives. Beware of applicable FRA safety standards. Recognize inspector discretion. Apply criteria Part 209 Appendix A when considering recommendation for civil penalty. Statutes versus regulations. Statutes enacted by the U.S. Congress filed with the United States Code. Safety Compliance Acts of the statutes cannot be changed or waived by any agency of the U.S. government unless such authority granted by Congress is able to have 49 U.S. Standard Code 2036. Rock Island Act allows FRA to waive the SA Act requirements for technological improvements or innovations. Statutes versus regulations. Regulations enacted for the rulemaking by agency U.S. government found in the Code of Federal Regulations. Safety Appliance Power Break Standard Part 231 and 232 are regulations. Interstate Commerce Commission orders are basically regulations. Can be changed or waived by any agency of the U.S. government. Other significant events in 1966, the Congress passed the Department of Transportation Act. On April 1st, 1967, the Department of Transportation and Federal Railroad Administration came into existence. And the 1966 Act transferred all powers and duties function from the Interstate Commerce Commission related with the Safety Appliance to the Secretary of the DOT, who is designated the FRA with authority. Other significant events in 1970, the Congress passed the Federal Railroad Safety Act, FRAS. Reason for action included upward trend in railroad accidents. In 1969, there were 8,500 accidents and 2,300 deaths. Data showed that the most accidents due to the track, equipment, and human factors. Many of these areas were regulated. Many of these areas were unregulated at the federal level at any significant extent. Major elements of the Federal Railroad's 1972 Federal Railroad Safety Act. It was jurisdiction given to the Secretary of Transportation, FRA jurisdiction over all railroads, not just railroads engaged in interstate commerce. Rulemaking authority gave the FRA ability to regulate all areas of the railroad safety. Emergency authority for the FRA to issue the emergency orders, preemption, basic principle of national uniformity. FRA rules given general preempt state rules. Major elements of the 1970 Federal Railroad Safety Act. The state participation permits state inspectors to play the same role with the federal inspector via the certification. General powers provides authority for FRA to conduct investigations, seek documents, conduct inspection of the equipment in operation. Penalties. Granted authority for the FRA to assess and collect the penalties between $250 to $10,000 with $20,000 penalty for gross negligence causing death or injury. Recodification. 1994, Congress recodified the existing federal railroad safety law. With the Congress intent was to consolidate all existing federal railroad laws under the one title of the United States Code. The Safety Appliance Act related written reissued moved the Title 45 to Title 49 U.S. Standard Code. Thus, the Safety Appliance Act ceased to exist, and the Safety Appliance Acts are now a separate chapter in Title 49 U.S. Standard Code addressing safety appliance. Recodification. When recodifying the federal railroad safety laws, Congress changed the language and structure of the Safety Appliance Acts. Congress made clear that the language organizational changes were in clarity and were not intended to change the intent, meaning of the substance of any of the existing railroad safety laws. Thus, all existing cases law still relevant. Statute of authority and history. Congress began enacting laws in 1893 addressing safety issues for the U.S. Railroad. Most statutes were found in the Title 45 U.S. Standard Code. Recodification July 1994. Federal statutes now found in Title 49 U.S. Standard Code. Recodification did not change the meaning of the law, only its wording and location. First safety acts were 1893 Safety Appliance Act, 1907 the Hours of Service Act, 1910 Accident Report Act, 1911 Locomotive Boiler Inspection Act, 1920 Signal Inspection Act. The Safety Act of 1970 Congressional gave the Secretary of Transportation subsequently delegated FRA with the authority to overall matters relating to railroad safety, including rulemaking authority as well as older safety statutes enacted prior to 1970. The initial transfer of the authority to interstate commerce to DOT occurred in 1967. Appendix A to Part 209, Agency of Policy concerning enforcement, civil penalty process, civil penalties against individual, assessment of maximum penalties, extent and exercise FRA jurisdiction, extraordinary remedies. Civil penalties, railroads. A recommendation by the Inspector of Chief Counsel to assess the fine of the railroad for noncompliance with federal regulation, civil penalty. Evidence of the noncompliance is presented based on written factual evidence contained in the report. Civil penalties, individual recommendation by the Inspector Chief of the Council to assess the fine on an individual for noncompliance with federal regulation is civil penalty. Evidence of noncompliance is presented by base written factual evidence contained in the report. Maximum penalties. Incident with non-compliance with the law, the FRA to do a set of the penalties commensurate with the severity of the violation. Requires extra effort and the detailed support with the recommendation, in addition with a covered letter of the regional administrator. FRA jurisdiction. FRA have the authority to regulate all matters pertaining to the railroad safety. Authority encompasses all of the meaning of the railroad transportation, including self-contained urban rapid transit system, and certain ancillary operations are also excluded with the FRA discretion. Extraordinary remedies, disqualification of the individual, criminal penalties, compliance order, injunctions, emergency orders. Enforcement tools, given the railroad, the verbal repair order, verbal warning, exemption, regional warning letter, violation, civil penalty, chief counsel warning, special notice, motor power and equipment track letter, or civil command penalties, compliance orders, suspension, injunction, disqualification, emergency order, and guidance of the chief counsel, asterisk. Railroad, verbal repair order. Verbally tell the railroad official of the repair of the defect of the rolling stock your verbal directive is binding, and the railroad is compelled to take appropriate remedial action before returning it to service. Railroad exemption. Inspection report complete with the documentation, non-compliant condition. Railroad violation, even the conjunction with exemption recommending civil penalty. Railroad special notice for repair. Generally, even the conjunction with exemption with the violation, remove the service locomotive or car within compliance with the Title 49 CFR Part 215, 229, 230, and 238. Railroad compliance order upside. When the civil penalty is inappropriate or ineffective required of the railroad to engage supplementary activity to achieve compliance. Change of the internal policy to develop a training program. Downside, a huge investment in legal resources to implement compliance order. Railroad injunction, even the district court judge required of the railroad to comply with the railroad law immediately. If the railroad failed to comply with the violator, could be held in contempt, which could result in criminal penalties. Emergency order may be issued by the FRA administrator either separately with a combination with the injunction and based on the issue based on some practice with the action and inaction with the creative of the imminent safety hazard which could result in the death of the serious injury. Track an emergency order, the special tool used with a special notice has proven ineffective and inadequate to abate the emergency condition. Individual verbal warning, personally notified the individual first level of supervised violation with the federal regulation. It may be appropriate to consider the documentation, individual non-compliant with an inspection report. Individual regional warning letter, the FRA must show that the individual has either willingly, knowingly violated with the regulation or has demonstrated unfitness for safety sensitive services prepared with the regional level with without input headquarters willful violation, table of knowledge of fact for the constituting violation, individual chief counsel warning letter, same criteria, regional warning letter, willfully, knowingly unfit, safety sensitive service warning letter with the chief counsel considered with a more stringent approach with a more serious than a regional letter. Individual civil and criminal penalties, same with the regional warning letter, willfully, knowingly, or unfit safety services, sensitive services, depending on circumstance of the nature of the violation. The criminal penalty only when someone knowingly, willfully falsifies or destroys records or reports required with the FRA regulation emergency order. Criminal penalties contain certain hazmat issues. Individual suspension, disqualification. FRA does not have to show that the person acted willfully with the recommendation of suspension, disqualification. However, the FRA must show either the person has history violating the FRA regulation or violation is so egregious as to preclude any litigated defense on duty of the use of alcohol or drugs resulting in the loss of a life or serious injury. Enforcement discretion. FRA does not have to respond in every situation not compliant with the FRA Federal Railroad regulation with a formal enforcement action. FRA can use the discretionary power based on the limited sources where I believe that this is the best method of promoting compliance. In most cases, the enforcement discretion lies within the inspector. Enforcement discretion is driven by 7 governing factors. When and what the action, 7 governing factors, and here it's seriousness of the condition of the act. 2, the degree of the hazard potential safety implications based on fact. 3, personal property harmed by condition or action. 4, current compliance record. 5, recent history of compliance. 6, what actions are appropriate based on the facts. 7, other immediate factors relevant to the circumstance. Governing factor number 1, inherent serious action. Severity of violation of probably the immediate circumstances and penalty schedule reflect takes into account some conditions that are inherently serious and use accident incident data to link seriousness. Govern factor number 2, kind of the degree of the hazard potential safety implications based on the facts. Potential for injury or property damage posed with the violation with the contents of actual facts. Governing factor number 3, person property harm with the condition of the action. First, it should be generally be considered the violation caused or contributed to the severity of such actual harm, appropriate enforcement acts, individual civil penalties, suspension, disqualification. Governing factor number 4, current compliance record with the collusion about the railroad, individual general level of compliance when the inspection observation was made. Look at the big picture. If the compliance of the whole is good, but it might be appropriate to just take the exemption with not the file violation. Conversely, with the big picture indicate with the multiple serious defect violations may be in the best course of action. Governing factor number 5, recent history of the compliance level of the compliance given the location. Use of RISPCs develop defective ratios, railroad division, geographical location, failure to adhere to the conditions stipulated with the SACP action plan. Governing factor number 6, what action is appropriate based on the facts, waive the benefits before deciding, prepare violations report, take time, which translate less time in the field, these selected based on the seriousness, frequency, or other compelling reasons. Governing factor number 7, other immediate factors relevant to circumstances given the violator's level of culpability or claimable. Was regulation violated newly or recently been revised? End of module 1.